Okay, hi everybody. I'm not sure what the time is. According to my computer, it's 1 minute to 7, but my phone says it's a bit earlier than that. Is it 1 minute to 7 or does any?
I've got 3 minutes to 7.
You've got 3 minutes to 7. Okay, so my phone is right and my computer's wrong. So maybe we better wait for a couple more minutes. Okay, let's begin. I think that's pretty well much 7 o'clock. Can I just start with a few housekeeping issues? First of all, or matters. I think most of you are doing it, but if you could keep your mic off until you wish to speak, that'd be great. Otherwise, we just get a lot of feedback through the system. The other thing I should say before I go too much further is it's been a little while since I've actually run a Zoom session. In fact, it's about a year. So if I'm a little rusty at doing this, please forgive me, and I hope that I'll get better over time. What I'd like you to do is during these sessions, if we have any technical problems and the system drops out.
Your old auntie and uncle had it not.
Thank you. Then if you can just wait 15 minutes, and if I'm not back online within that period, then we can just take it as the session is cancelled. I believe that you have a hand raising function. I can't see it in front of me, but if you want to ask a question, because I can only, even if you've got your camera on, I can only see a few of you on the screen. So if you start gesticulating, then I'm not going to be aware that you're actually doing that. So if you can use that function, please, that'd be great. Or alternatively, you can put something in the chat. Now, I might stop from time to time if there's a lot going on in the chat and address it. I noticed that I've already had one question here about the text, or not the textbook. There is no textbook. That's one thing that I should say. So you are not required. The materials that are put online are in substitute of a textbook. I did have a question about the criminal processes in Queensland book. As far as I'm aware, and that's the book that I referred to in the introduction recording that I put online. As far as I'm aware, there's an e-copy of that in the library. If it's not the case, then I'm sure I've got a copy of the relevant chapter somewhere, even if it's a slightly marked up copy of that chapter, given that it may be one that I almost completed at the time of sending it off for the purposes of publication. Has anybody looked for that in the library as an e-copy, and did they find it, more importantly? No, if you can just respond if you have found it. Okay. Now, there's a couple of other things that I wanted to say. There's a couple of links on the first study guide that aren't working. I think they're links to videos that you'll find that they just don't seem to activate that relevant material. The material is on the subject web page though. So if you go to the web page, you'll be able to find those two videos. I think it's one's one of Thomas Frank's video, and the other one is one of Scott's videos, or no, it's Scott's materials in relation to the primer materials that I'm going to look at in a little minute. The final thing that I should say is that I know that there is a clash for some students, and some students have enrolled in this subject in conjunction with Introduction to Law. That it is advised that you shouldn't really be doing this subject and Introduction to Law together. Now, you can do that, but it's recommended that you don't, because there is some assumed knowledge in this subject, in that assumed knowledge, is that you would have acquired in Introduction to Law. Now, there are a number of subjects that don't have assumed knowledge that are available to first years, such as statutory interpretation, contracts, torts, or constitutional, that are options if at all possible. But as I said, if they're, given that we have a clash, these sessions, and indeed I believe the Introduction to Law sessions, will be recorded, and accordingly, if you have to do this subject in conjunction with that one, you will be able to access the materials. Okay. This is just me saying this. I went through all the materials dealing with the College Geek materials, and I know that many of you have looked at this before, and I highly, if you haven't, I think there are about 5 videos that are provided for this first week, and I found them to be really useful. I wasn't familiar with them until I started preparing for this subject. But I found them to be really engaging and had some great ideas. And I must admit that some of the stuff that he recommended, I thought, I've stopped doing that. And I accordingly started to implement some of the things he suggested. Particularly, I think my major thing was I'd stopped using an online diary. And I went, all right, that's it. I've got to start being more organized, and I have done that. Also, I thought the one in relation to workspace was really good, and the one in relation to habits, of breaking bad habits. Now, so have a look at those if you haven't done so in the past, and even if you have, it might be worth refreshing some of it. The legal research primer, I believe that you've looked at this before. Is that correct? Some of you will have had this primer in probably Introduction to Law. I just wanted to go through this a little bit, very superficially, if you like, or very cursory. I'm not going to go into any detail, but I wanted to use it as an example of something that's in one of the videos that's in your material that deals with active reading. And I think this is a really, really good point, that it's really good to, when you read something, to not just read it because you won't take a lot in, but sort of with a critical mind, read it with a critical mind and make notes. Now, even with that particular, I'm going to bring it up if I can. Which one is it? Go back to the, is that it? No, that's not it. Try again. Here it is. Just to give you an idea of what I do, even on something like this. And I'm doing this for a couple of reasons. One is in relation to the active reading element of it, but the other one is just to go through a few things that I noticed in here that I wanted to bring your attention to. And I should have, just a moment. Here we go. Okay, so I know he says in this primer that you shouldn't highlight things. It's a waste of time. I'm actually a great highlighter. There's a few things that I wanted to bring your attention to for the purposes of your research project as we go through this, is mainly. One is in relation to government reports. I guess this is a general point. You see here that he talks about, you've got a number of sources that you can use for your research. One of those being government reports. I guess what I wanted to emphasize here is that you really need to be cautious with government reports. Some of them are done at arm's length, if you like, so that there's a committee established, and those reports will be quite good. And others are, to want of a better word, basically legal, or it's not legal, sorry, government propaganda. So in other words, it's all about how good the government is and what they've done, et cetera, et cetera. And a lot of the time, those sorts of reports have very little in them. So you've got to look at government reports with a critical eye and say, look, is this really of any great weight? So with your research, you should have a distribution of sources, many of which will be academic and legal primary sources. That should be your focus. Government reports are higher, if you like, than media reports, but some of them are not much in terms of their weight, not much better than that. Another point that I wanted to make in relation to it is citations and referencing, and not so much in relation to plagiarism. I have a very, very old-fashioned way of doing this. I'm sure that you have much better ways of doing this, but what I tend to do when I'm researching a topic is that I like to have paper in front of me. So I print most of my documents. I seem to retain the information better. In order to organize that, I will start giving them a title. So each document, maybe one focuses on, for example, I'll call something like a general overview. And then I'll have general overview 1, 2, 3, 4, and I will keep reference to that. So by just putting initials on the top of that page, on the top of that document. So I'll go, general overview, I'll just GO1, and then reference the page number so that when I'm typing, I don't have to constantly put in the entire citation. It's just, you can use the electronic online sort of systems, but I've always found that to be a particularly effective mechanism to keep track. If you're somebody that uses a lot of paper documents, I think it's a really good idea to come up with some sort of way of organizing them and the use of abbreviations of some kind. I wanted to emphasize the statement here. I'm sure that you are familiar with this, that it's not your final answer that matters, but rather the argument you engage in the process of preparing that. So in other words, it's what you've written. It's not what your final conclusion is. It's the way you've mounted your argument. It's, I guess, something that I put down here a little further was you need to refine your argument or refine your topics, which we'll talk about in a minute, and then try and put yourself on the end of an argument. Now, what I mean by that is if you find that there's a debate going on, and there's always legal debates going on about how best the law should operate, then you sort of want to go, okay, I've accumulated all this knowledge by written sources, and I want to put myself at the end of that argument or that discussion, if you want to describe it that way, and add something to it, but I'm going to engage with that process. I hope that's a good way of describing it. I've got it made reference to that down here. Now, the other thing that I was going to draw your attention to is when we talked about citing authorities, as you know, you've got to use the Australian Guide to Legal Citations. Be careful in the way you do that. There's some really easy mistakes that people make. One of those is in relation to the term judgment, and this document in fact does that. It consistently misspells the word judgment. What is the correct spelling of the word judgment? When does, or put it another way, when does judgment have an E and when does it not have an E? Does anybody want to suggest the answer to that question? You want to turn on your mic and just answer it?
Yeah, I was told you can't go wrong if you throw an E in there.
Yeah, judgment, when we're talking about, thanks Nicholas, the judgment of the court, though, it doesn't have an E. The judgment, so if we're referring to the judgment of any court, then it doesn't, as you can see, I'll put that E out. If we, so if it's a single judgment or the judgment of if we're talking about the judge's own opinions or judgment, then it does have an E, not as opposed to what his judgment of the decision or that decision is. Does that make sense? So just be careful of that one. It's one that I constantly go through and correct. I guess, look, what I should say is that I'm not a complete pedant when it comes to these sorts of things. Not a great speller myself, I'll make errors, but when you're dealing with a specialty area and the law is one of those, then you've got to conform with those sorts of, it's a bit like the term, the idiosyncrasies, if you like, or the way things are spelt in that particular discipline. One of the other ones that drives me nuts is, for example, is the word defense. Now, American spell checkers will put it with an S instead of a C. Now, you know, if you're talking about a criminal matter, for example, then really you've got to be careful of those sorts of things, because it's a technical term that we use in criminal law, and we should at least make an effort to get those types of words correct. You know, practice, legal practice as opposed to practicing, and etc. There's a whole bunch of these things. Okay, so watch out for those. What else is there in here that I was going to talk about? The reference to making sure your legislation is up to date. Don't get too hung up about that. I think most of you know this. Yes, be up to date. You've got to always be up to date, but it's not like Parliament's making changes to legislation on a weekly, monthly, whatever basis. So if you go and look up the most recent copy of the legislation, there's a good chance it's not going to be changed until such time as you submit your work. You might want to, for the most important parts, go back and check right at the end to make sure that hasn't been changed. Having said that, I once wrote a whole, I think I spent like 3 months trying to get my head around the Victorian consent laws, only to get to the end of it and write it up, and all the other states seemed quite straightforward, but the Victorian laws were really, really hard and difficult to try and get your head around. I put the chapter aside for a little while, and about a month later I came back and found that they'd realized just how difficult they were and repealed the lot and gone back to something that was much different to what I'd spent 3 months looking at. So you do have to be careful with that sort of thing. You can get caught, and that was an example of where I almost got caught. And I was lucky that I went back and had a look. And I was also lucky that they changed the law so in Victoria, so it almost reflected the same laws in relation to consent as exist in Queensland. So that was and I could look at them and go, oh, well, that's easy. But don't get too hung up, I guess. Change doesn't occur on that regular basis. Definition sections, look, this is something that's pretty obvious. Most acts have a definition section, but like the acts that we'll be dealing with for your purposes of your research, some of the chapters have their own definition sections, and indeed, watch out for sections that actually define words within them. So in other words, even within a chapter, you might have a particular section with its own definition. So always look out for definition sections within acts. Some of this are just notes to self. An example of where you can get caught out, I looked at this, for example, on accessing cases, and it talked about the fact that Australian, Queensland reports are only available up and back to 1994 online. That's not actually true. I suspect it might have been true when this primer was written, but if you go and have a look, you can get Supreme Court's decisions back to 1979, and you can get Court of Appeal decisions back to 1992. So just be aware that if you want to go looking for decisions online, that statement that you only got back to 1994 is not in fact correct. So you might want to change that. It's Scott's documents, but so I can't go changing it for him and loading it up again, but just be aware of that one. Okay, any other thing that I wanted to bring to your attention? I'm just quickly flick through. Same point as I made before. Dictionaries. This is another one that I've regularly raised with people when they're doing a research paper. Use this very sparingly. Don't. Dictionaries, even legal dictionaries, are problematic. And there's a good reason for that, is that a term quite often has a very specific meaning within the area of law with which you're dealing. So if you're dealing with an administrative law, a term would mean something slightly different than if you're dealing with something like torts law. So a general dictionary definition doesn't get you very far. And it can be downright misleading at times, because the legal definition dictionaries invariably will be jurisdictional specific, and they don't tell you that. So if you've got an area of the law that differs between the Australian states and territories, then the worth of the dictionary is even less. So just be very wary of dictionaries. In any event, it doesn't really show a great deal of research ability, if you like, to go and look something up in a dictionary. So just watch out for that one. Just, I think the last point, of the second last point that I was going to make in relation to the primer, is one of the, I think, useful things to do, and this is, at least I always found this useful as a student, is that if you're going to write about a particular area of the law, I always found it useful to go and get a couple of journal articles that were about that area of the law, and then look at them for the way they structured their argument and presented their arguments. And I'm not talking about what the actual content is, but just how they went about doing it. It's a really useful thing to sort of go, and there's no harm. You're not plagiarizing here by ripping off the structural approach of various articles. And I think that's a really useful thing. Go and look at how people write within the area of hate crimes, and not for the content, but purely to see how they present their materials, and then put a structure together that's maybe similar to that. The only other thing that I was going to mention here, I think, apart from, was just a moment. Yes, was right at the end. There's an exercise right at the end. Be careful of this one as well. Just right here. You can see that I've gone through and cut out, and this is another one. The use of the word section in the example that's given is not consistent with the Australian Guide to Legal Citation. You don't use the term section unless it is at the beginning of a sentence. If it's at the beginning of a sentence, you wipe the word out. Everywhere else, you simply put S29. It's just be careful with that one. You can see that I've left it where it's at the beginning of a sentence, but well, I didn't there. There's one there as well. That's a good example of what you just cross it out. Saves me having to do it when I'm going through your work. So there's another one that just watch out for. It's fine in a heading, but otherwise it's just the S. Here you can see that I've gone through that. Okay, so that's the primer. Do we have, or are there any questions that anybody has before I go on to the research topic about the assessment more generally?
Is there somewhere we can get a copy of your notes on the primer?
I'll find out whether I can do that. I raised this and was told that because Scott had prepared this, and don't get me wrong, this is a great primer, but I've engaged in what I described at the beginning, as that I've gone through this with a critical eye and gone, look, I went through my own preparation for the materials on your major report. What's it called? The research program paper as well. And I found that I referred to the committee as the commission. So I went through and got annoyed with myself as well. So I do this in relation to my own work as well as to Scott's. I'll try and find out whether there's a way that I can do that.
Or even just like the for reference of some of those points that you've just made.
Yep. Okay. And maybe I can put a bunch of them together and just say, look, this is what to look out for. Yeah. Okay. No, I don't. Yeah, I'll do that at least. Okay, let's get rid of that. Stop sharing it.
So just go back to with regards when you're talking about judgment, is like a personal. In my personal judgment is
Got an
one,
E.
Got an E, and the judgment made by the court doesn't have an E, or
Correct.
Yeah, so the authoritative judgment doesn't have the E.
Yeah.
And a personal opinion sort of style has
Yep.
E. Okay. Cool.
Yep.
Okay.
So you can. I mean, the really confusing thing is when the judge expresses his personal judgment, as in his opinion about something. Then it's got an E. But usually when it comes to judges expressing a judgment, it's not got an E. But yeah, you're right. Okay. The other thing is also try and avoid I know automatic correction always puts a capital for the S as well. Avoid that as well. It's a small S. So just watch out for that one. Okay, so did anybody find any media releases on the topic of serious vilification and hate speech that are recent? Does anybody find anything of interest?
Malcolm, I put it in our little chat thing there about the kerfuffle that's gone on about the 3 English soccer players that have been vilified over their poor performance.
Yeah, it was I think there was in some Australian media, for example, they referred to 3 and referred to their colour of their skin. English players missing. Not a huge soccer aficionado, but missing their shot on goal or whatever, their penalty shootout, isn't it? Their penalty shot. So yeah, that's one of them. Yeah, great. Thanks for that. Did anybody else find anything?
I found one about a hate symbol being used at Disneyland, where parents discovered photos of their child, and in the photo, the character had used the upside down white supremacist symbol in the photo as he was holding the hand of an Hispanic child.
Okay. I didn't see that out. That's interesting, Kelly. Okay, good. Yep. I found a couple. Let's see if I've got them here. Now, just seeing where they've gone. No, I can't. I thought I had them open on my. Maybe it's because I've got. No, I can't see. I'm not sure why that's not coming up, but I can't see. Anyway, I'll just describe them. There's a couple that I found. I'll just describe them to you. These were one, and the reason I thought these were interesting. There's one, and I'll send you some links for them too. One's from the UK, so it shows a conflict between hate speech and freedom of speech, where the Conservatives were going to introduce a freedom of speech bill that would, according to the opposition, would give a legal basis for people engaging in hate speech anti-vaxxers, as they refer to them, Holocaust deniers, etc., an action for making sure that universities allowed them to express their somewhat abhorrent views. So it's a classic conflict between freedom of speech and restricting that by reference to its impact on certain demographics. That was one that was this week. It was it was Sunday, the 11th of July. So yeah, that was, I'll send you the link for that so you can have a look at that. Another one was in relation to, which didn't find all that interesting, but Facebook had paid for a review of its methods for dealing with hate speech. And there was a report, this is from the 9th of this month, that was released saying where Facebook had fallen down, if you like. It compared various countries, including India, Myanmar, Indonesia, Philippines, and Australia, and looked at how they were addressing complaints about hate speech. I'll again send you that. And the final one that I thought was also really interesting, and this was a little dated, but it came from the 23rd of last month. And the reason I thought this was interesting, because it might provide some of you with an avenue for further research. It is the fact that the Liberals in Canada, which is the current government, have introduced into Parliament a bill that amends the Criminal Code of Canada and the Canadian Human Rights Act that specifically targets online hate. And it goes into, again, the fact that the opposition was complaining about the restrictions that would be introduced on freedom of speech as a result of this. So it goes, but it demonstrates that there are a number of jurisdictions, and it actually goes into, this article goes into some detail, and it talks about the basis for the restriction. So it's on the basis of race, nationality, ethnic origin, language, color, religion, sex, age, etc. So in other words, any sort of hate speech based on those, and physical disability and mental disability, sexual orientation, and gender orientation, etc. So it's quite a detailed article. It's worth having a look at, because obviously there are a number of jurisdictions that are currently looking at this. I can tell you that the UK has also had a report dealing with this. Victoria, there's all sorts of reports by law reform bodies of some description, and some of these are really quite long. I think the UK report's about 500 words long. I mean, you don't, it's a bit daunting. I didn't read it. I have read the submissions to the Victorian one though, and that they're rather interesting. I was just reading your some of the comments. Sorry, I was just stopped that. Yeah, sorry, somebody's going to say something.
Yeah, Malcolm, my wife and I watched Wild Wild Country. I don't know if you've seen that one on Netflix. It's a docu-series, and it was about a religious movement that started in India and relocated to Antelope in Oregon, America.
Okay.
And yeah, it was the vilification and the abuse that they experienced when they arrived, and then which subsequently led to, like, there was a lot of crime and stuff that ended up happening, and they were perceived as a hostile threat, as a takeover, that you're changing our way of life and we don't like what you're doing here, how you come here and don't assimilate and that sort of thing. And yeah, it's a really good watch. But yeah, sort of tied in with that there.
Oh, sounds interesting. Can you put something on the webpage about that, so a reference to it, so we know what it's titled?
Yeah, for sure.
That'd be great. Thanks for that.
Yep.
Okay. There was one, and I didn't save the link to it. Actually, there was one in Western Australia, because it was earlier on the year where I think a woman was racially vilified by a guy with a white swastika printed across his forehead, and he chased her down the street yelling racial abuse at her. So I did read that was in about February this year. That was rather, got a bit of media coverage about that. And in fact, the Western Australian government is sort of looking at some, so I don't think they got very far. I don't think they're as far advanced as Queensland is in doing some sort of law reform project on it, but I think that has motivated them to look at it. The other thing that I wanted to just raise with you, and I might put a link up to this on the web, on your Moodle page also, is the other really interesting, and I'm digressing completely here, sorry, I've just bear with me for a minute. The other really interesting bit of law reform that's going on in Queensland at the moment is the Women's Safety and Justice Task Force. There's been the Justice Department in Queensland has put together an impressive list of, including former judges, of people to look at how mostly the criminal justice system, what if you, for want of a better way, interacts with women and girls. Specifically, I think high on that agenda is that they're looking at, and I know former Justice McMurdo is heading this up, is looking at coercive control, which has become the focus of attention for many people due to the sorts of examples we've seen of women being killed by their former intimate partner. And I mean, we had a law reform process where we ended up with an offence of strangulation, where somebody puts their hands around a throat because it was a precursor or indicator, a common precursor to somebody being killed by their former intimate partner. Coercive control is another one. If you look at some of the materials on coercive control, there's I think she was an SBS journalist who's written a book about it. I can't remember her name for the life of me. I attended a webinar at the beginning of the year that she presented on that book, and it was fascinating. I think there's a 3-part documentary on SBS as well, which feature her findings in relation to that book. And at least I was quite gobsmacked by the extent of people's control over others. It's really quite horrifying. I'm sure some of you may have read about it. But anyway, for those that are interested, I think that's another current law reform project that's underway right now. I think it's due to finish early next year, but if anybody is interested in engaging with that, I highly recommend it. And as I said, I'll put a link to that. To that web page where they explain what they're doing, and etc. etc. Okay, so given that our topic is in fact vilification laws and hate crime, I just had a little poll here. Launched the poll, and I'd be interested to find how many of you actually find the topic an engaging topic to address. A few no's, a few yeses. Actually, we're 50-50.
Sorry, Malcolm, what was the poll on again? Sorry, man.
Whether you find the topic of vilification and or serious vilification and hate crime as being an engaging topic. So it's just a simple yes, no. Can you see the poll there?
Yeah, it's popped up.
Okay, so I'll finish it there. I've got 29 say yes and 10 say no. When I chose this topic. That, in fact, the other topic the one that I just referred to in relation to coercive control was one that I had considered as being an alternative. I decided to go with this one instead for a variety of reasons. I think probably most importantly because some of the content of the other one, neither of them are pleasant, let's be honest. Some of the content that you end up looking at, I think coercive control is even more, much of it is even more confronting, and I thought maybe perhaps it's not ideal. Okay, so I guess for the rest of this session, what I want to do is try and narrow down, and I'm going to do this the type of topic you can do. So I'll just bring up the slides. By that, what I mean is I'm going to, I hope I've done it. Yes. I went through the terms of reference of the committee and sort of identified in highlight, by way of reference to highlight, as to what I thought, from my perspective, are context material and that which will provide a real basis for legal research. Does that make sense to everybody? In other words, some of this material is not really, the terms of reference aren't ideal for a legal paper. So the first one there, for example, I'd say it's content material. It's not the focus of your research. So the extent to which hate crime or serious vilification in Queensland, or the nature of it, extent of it, and whether there's evidence of increasing occurrences, will provide really good context material, but you shouldn't focus on that. The second reference there, however, the effectiveness of section 131A of the Anti-Discrimination Act, which is the offence provision and other existing laws that address hate crimes. Now that provides you with substantial legal content to engage with. I guess just be aware when it refers to other existing laws that respond to hate crime, it's not talking about other laws that specifically address it, but that are used in relation to hate crimes. And when we get to the end of this session, if we've got time, I put together a little diagram of all the laws that I thought would relate to hate crimes in Queensland. I just made a sort of a flow chart. Instead of doing your flow chart, which you have to do for the purposes of this week, I did one on the laws relating to vilification and hate crimes. The second part of it, the opinion paper, which I highly recommend. I think you've got a link to it. Have a look at it. But again, it is very general in its nature. It's going to give you a great review or an overview of the law that's relevant here. But again, it's sort of background material rather than being the focus of your research. The interaction between Queensland and Commonwealth laws in relation to online vilification is an important one there. And you'll note that the federal government has just, I think, introduced amendments to their laws in relation to online vilification. So I think about 3 weeks ago, they announced that they would make certain changes that made it easier to remove offensive online material. So that area of that reference there is something that would be provide quite meaty legal content, if you like. The effectiveness of government agencies in dealing with the problem, again, it's more content or context material than the focus of your research. On the other hand, the reference to the Human Rights Act of Queensland is exactly the sort of area you could look at. Here, it's talking about section 13, but section 13 is a general provision. We'll get to that in a minute, but the potential for conflict between rights is always been, and as you can tell by the sort of news items that I raised, and reference to the constitutionality or the conflict in terms of the state and federal governments legislation in this area. You'll find that there are quite a few cases, for example, in particularly in Victoria, where similar laws have been challenged on the basis that they are unconstitutional. Now, they haven't been successful, but that's been one of the arguments that's been presented. The current legal framework, of course, is again a very broad statement, but how you refine that's up to you. Here you can see you've got the comparative reference here to other Australian jurisdictions. Now, it also says international jurisdictions, and by all means, take that to mean two things. One is other nation states or countries, however you want to describe them, such as Canada that I referred to, the UK or whatever, but also, this is not its usual interpretation of this term, but international law itself. So in dealing with the International Covenant on Civil and Political Rights, or the International Covenant on the Elimination of All Forms of Racial Discrimination, which I'll refer to in a minute. So that's the sort of thing you can do in there. And finally, you've got a reference to the appropriateness of the conciliation-based anti-discrimination framework. Again, that could be a focus of your research. Now, I'll come back to some of this. There are 4 references there that, when I pick this up and say this is a reference, terms of reference, there were 4 things that I instantly want to do or look at. Does anybody have any idea what those 4 things are? Anybody want to suggest one? Oh, it's a straightforward question. I'm not being tricky here.
The legislation?
Yeah, well, and by and large, that's what all 4 are references to. Not all 4, but the 3 of them are exactly. So I want to know what Section 131A of the Act is all about. Now, to me, as somebody who's been heavily involved in criminal law and indeed human rights law, I still find this a really perplexing section, in the sense that it's not easy to follow. So you want to look at this and say, well, what is this about? Now, having a look at this, what can you tell me about it? What type of section is it? Just have a quick look at it and think about it and tell me what you immediately jumps out at you, or what jumps out.
It imposes an offence?
Yes. So it imposes an offence. So it imposes a criminal offence. Is that's what you mean?
Yes, that's what I mean.
Yeah. No, that's fine. How do you know that?
By the language that's used. It doesn't refer to a misdemeanor or any other term. It refers specifically to an offence. Yeah, that's right. It does have the words offence in it. Mind you, that's in the title, and it doesn't actually use that same terminology in the section itself. Look, it's a good indicator. The only real way you can tell that that's an offence is by the fact that it's got penalties, and the fact it's the next section, if you like, this one, the fact that you've got imprisonment and a penalties. That's how you can tell that it's an offence. Okay. I did have a little, I might, I'll come back to that. I've got another poll that I'll do in a minute. Okay, so anything else that jumps out at you? Apart from that, you're right, it's an offence. It's a criminal offence. I think I would note also that A and B are separated by the word or, so it's not, you don't need to meet all of the thresholds in the section. Sorry, it's probably not the best way of expressing that, but
that's fine. In fact, that's what I've done here. It's alternatives. Okay, so the elements of that offence you can see are fourfold, and you've got with 2, 3, and 4 there. they are all alternatives. So it's got to be a public act. There's got to be a mental element of knowingly or recklessly doing one of A, B, or C, inciting hatred towards a person or members of a group, inciting serious contempt for a person, one of those. It's got to be on the grounds of one of those. So it's not only the fact that it's on the grounds of, let's just stick with the first one, of race, but it's got to be the race of the person or members of the group. And it's got to have a outcome, if you like, in the way that it includes a threat to physical harm towards members of the group, or a threat towards the property of those persons or members of the group, or an incitement to others to threaten it, or the person or the property of. Does that make sense to everybody, how I've done that? Can you see how that, the section when I've extrapolated out? Yep, good, great, thanks, Nick. Yeah, so good. It's great to, I mean, because this is our primary focus, it's really worthwhile sitting down and really pulling apart the sections and seeing how it works. So, you know, I spent a bit of time doing that today. So let's get back to the section itself. Is there anything else that you note? Okay, the other couple of things I, you know, as somebody sort of dealing with these criminal law for a long time, one of the first things I note is that it's got a mental element. It's, I already mentioned that, but that makes it more difficult to prove. It's got to be either knowingly or recklessly incites. So you've got, the accused has to either do it knowingly or recklessly. Okay, so the inclusion of that, of course, means that the person has their reason for acting, if you like, is to incite hatred knowingly, or in the case of recklessly. And I guess one of the things about the law is that if you go and try and find a definition of knowingly or recklessly, you won't find it in the Act. These are terms that you have to extract from cases. But the term recklessly is widely accepted as knowing of the probability of a risk that something will happen and going ahead regardless. Not that it's your reason for acting, but knowing that there was a probability that that would happen. Now, reckless in different contexts can have a slightly different meaning. It can mean knowledge of the possibility that something might happen. But in this context, I suspect, and I'm not telling you that this is the case because I haven't got any authority for this, but this is generally, it means knowing that something will probably happen and going ahead with it. Okay. The other thing that I was hoping somebody might refer to that is useful as far as the research is concerned is the section number. What can we extrapolate from that section? 131 capital A. What does it tell you?
It's been added in after the fact.
Correct. Exactly. So, Amy, what that means, of course, is that if we want to find something out about this particular amendment, it's not going to be in any of the explanatory notes, etc., that accompany the 1991 Act. It's going to be subsequent to that when it's been amended, and that was in 2001. So exactly. So we're going to have to go and look and see the particular legislation and any sort of explanatory note that came with that, if we want to know what they were trying to achieve in passing this. So yeah, great, good. Okay, so anybody have any idea of what type of offence it is? we'll go to my, maybe we'll do my other two little polls. Well, in poll.
Criminal.
Yeah. See if I can. I had I'm not going to worry
That's
about.
the old poll. That's the last poll.
Yeah. I'm not sure what happened to the edit. No, I had some other polls there, and I'm not sure why I can't get them. I'll tell you what, I'll read them out to you. Can you think of, because I'm not going to be able to get those. At least I don't think so.
Can you
Anyway.
just put up the penalty page again?
Yep. Or did I close that? Can you see that now? No, because I've stopped sharing screen, haven't I? Just a moment. Share. Okay, so one of my polls was, and rather than doing it as a poll, what is a penalty unit? Because if you go to here, you can see that the penalty is 70 penalty units or 6 months imprisonment. I had a selection here. A penalty unit is an apartment for naughty people. $75, $120, and $110. Does anybody think they actually know the right answer? And why? Okay, maybe I'll ask another question. How do we find out what a penalty unit is?
It's in the Sentencing and Penalties Act.
Correct. And I think it's I think it's section 5, Nick, and it will tell you that a penalty unit is $110. So yeah, good. The other question I had is, and I'll tell you what type of an offence this is. This is a simple offence. Does anybody know what the distinction between how we know this is a simple offence? Somebody mentioned a minute ago, this is not a crime or misdemeanor. And that's correct. Does anybody know why we know that? This is a bit of a disadvantage for those that don't live in Queensland and have to deal with the Queensland Criminal Code. The answer is simple. If we go and look at section 3 of the Queensland Criminal Code, it tells us that effectively what it says is this, is that anything that's described as a crime is a crime. Anything that's described as a misdemeanor is a misdemeanor. And anything that's not described as one or the other is a simple offence. This is not described either way. So this is a simple offence. Means that a simple offence is simply one that's described as being everything else, in Queensland at least. Other jurisdictions have different definitions of what a simple offence is, but that's what the definition is here. It's everything that's not a crime or misdemeanor. What is a crime or a misdemeanor? What's the distinction between those two? Doesn't really matter for our purposes because we're not dealing with any here, but they, at least in theory, are indictable offences. In other words, they can, in theory, crimes or misdemeanors be heard by a judge and jury. Now, I say that in theory because a lot of them are heard summarily. So there is, but that's the distinction. Okay, good. Now, one of the things to note within relation to going back to why I told you that is that there is a different procedure with simple offences, which means that, for example, I'll give you a good example. Under the Justices Act, Section 52, a prosecution has to be brought within a year for a simple offence from the date of the relevant offence occurring. And if you don't comply with that, then it's too bad. You can't convict. So those sorts of little differences, usually time doesn't run against the Crown when it comes to crime, and that's right, except for as it relates to simple offences. So in other words, you know, we all know that if you murder somebody or you commit some other horrendous crime, then it doesn't matter whether it's 10 years, 30 years, whatever. But within relation to simple offences, there is a time restriction. Okay. There's also other things like the procedure's different and the penalties are usually different, et cetera, et cetera. But that's an important one as far as the fact that we are dealing here with a simple offence, and it's quite often the case that it might be difficult to bring a prosecution within that year time frame. Okay. Anything else about that section that you want to identify that sticks out to you? Just before we move on. I think some of you actually raised this with me in the icebreaker activities.
I thought it was interesting that you had to get written consent from a Crown Law officer before it could be brought.
Yeah, Kelly, that's the one I was referring to. Yeah, exactly. Yeah, there's a few offences where that's the case. Things like conspiracy, for example, but they're not many where you've got to get approval before you can commence. Now, conspiracy, the reason for it is it's been so controversial over the years, and it's that it's used for semi-political purposes at times. So that's why there's a restriction on that one. Here, why we have such a restriction, it's a little bit difficult to know, and I think it's one of those things that's recommended should be removed. So yeah, I think that's another thing that sticks out as well. Okay, now in the absence of anything else that jumps out at you, I'm going to move on to the other, which is section 124. That's also the next, and I've not broken this up. I'm not broken this up at all, but I'll give you a few pointers in this relation to this. Now, this is not a criminal offence. This is a civil action. It's got the same basic test, but no mental element. So in other words, it's incite hatred towards, serious contempt for, serious ridicule, and it's based on one of those same things: race, religion, sexuality, and gender identity. And I forgot to mention when I was talking about that before, when you look at the Act, you'll find a definition of public act. You'll find a definition of race. It's a very broad definition because race is really a social construct. So it's got this really broad definition. There's no definition of religion. There is of sexuality and there is of gender identity, but that's about the only things you'll find with the definition in the Act itself. So yeah, you've got something very similar. No mental element here, and there's no need for a harm consequence. You know, remember the threatened harm, et cetera, in the first one. That's not here. So the other thing I was going to mention to you is that there is a similar provision in the Commonwealth Racial Discrimination Act under section 18C. But as the term suggests, there's two things I'm going to say about that. One, as the term suggests, it's only about race, and two, it has a lower threshold. So it's easier to prove it. This is still incite hatred, et cetera, is still quite a high threshold. Okay, sorry, I'm just sort of rushing through at the moment now because I realized that we've gone over our hour. Do you want me to continue or do you want me to truncate it at this point? Okay, I'll just go on for a little bit more. Okay. I don't have a lot more to deal with. The The third one is the Human Rights Act. The section referred to Section 13. Section 13 is about the limitations that can be placed on human rights. It's there. All human rights can be limited, and this has got that limitation. And obviously, Section 21, freedom of expression, is the most likely one that's going to be impacted upon here. Okay. And finally, the last one that I said there were 4 things that stuck out is the options paper, which I'm going to leave for your review later. Now, before I do my last little thing with the graphics, I just wanted to make sure that people are okay with the workshop activities. Are there any questions that people have about your own workshop activities? Because you've only really got 2 things to do this week.
I have a question just in terms of like spending our time and how we are sort of gathering all of our information for our assessments.
Mm-hmm.
So from my understanding, and I could be a bit confused, but is the idea that we select a research topic,
Yep,
and then we use the workshop tasks to complete throughout the weeks? They become our assessment 1 and 2, and they're on the same topic as our research project, and then we submit the research project at the end.
correct. So in fact, the portfolios that you do, like this week where you've got the red writing, where you've got to do that, the aim of that is to get you moving through your research project, the one that you're identifying. That's the point. So it's to get you started in so this week, for example, the doing of a graphic in relation to the shareholders, the stakeholders, is designed to make you designed to get you in thinking about where you're going to go with this. So that's exactly the point. Yeah. So is that? Yep. Good. The other thing, of course, is that there are 2 little projects that you've got to do that are completely unrelated. So you've got the one that you've already got, which is about access to electronic devices, the telephone. Yep. And there's one that's not written yet. Does that make sense? A little scenario that you have to answer.
I haven't seen that yet, but
okay.
I'll have to look into it.
Yeah. There's one there that there's a little question that I wrote about somebody attending a concert at the tanks in Cairns, and there was a police enforcement, and it's just asked you to do some research into the relevant laws, the powers of the police. So yeah, and there's the second one in relation to that. I think it's a 1,200 word answer you've got to give. But
okay, is that part of our portfolio, is it, or is that separate?
It is included in that. Yeah, so if you go to portfolio part 1, it's at the end of that.
Okay, fantastic. All right, thank you.
Okay, finally, where are we? Stop sharing. And I'm going to hopefully. Why isn't it there? I was going to share, but I can't see it. Why is it not? Perhaps I can do this, just a moment. Nope. Okay, I'm not having much luck here. I was hoping to share with you a graphic that I did. You've been asked to go on to, I just can't remember the name of where you create your little flowchart thing for this week. I did one. Maybe if I work out how to share that next week, I can do that. But because it relates to, as I said at the beginning, I've done mine in relation to all the sections I could identify, including the various criminal offences and that relate to the section 131 capital A. And I also included things like Commonwealth Acts and international conventions and relevant sections to those, or articles within those conventions, but I can't seem to find how I share that with you at this moment. So given the time, I think we might leave that and I'll work that out for next week. I apologize for that. But I'll share it with you later. And if not, I'll put access to it on the Moodle homepage. Okay, any questions to finish off with?
I would like to jump in to ask about questions about the legal skill metric in each of the week. Do we need to answer them, or we just self? Okay.
No.
Okay, thank you.
Okay. I didn't mention, oh no, and I mentioned in the introduction video. I have to, I mean, I looked at those. I didn't prepare those, to tell you the truth. And I looked at those and found them a little confusing, and I hope that you don't. I certainly wouldn't get hung up with those at all. I mean, if you look at them, what they basically tell you is the progression through legal skills. That doesn't, I mean, I guess you can reflect and say, am I doing this at this part in my education? But I certainly wouldn't get hung up with those. And I think they appear on every one of the modules, but yeah, it's a little bit like the marking grids, or the matrix. Don't let them dictate how you prepare your paper. You know, do the other way around, prepare your paper and look and say, where am I meeting these criteria? Don't go and look at the criteria and then try and write your paper. It will just confuse you. So please don't do that. I guess what I would make the point is that this is a little concerning for people, but we by and large engage in what's referred to as qualitative assessment, not quantitative. In other words, we don't line up with a bunch of criteria and go tick, 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 that must equal 42. We look at the quality of the work as the primary focus. Now, you'll see that Scott's videos talks about this. He talks about it in terms of research, but it's also the case in terms of marking. Okay. Any other questions?
So just one quick one.
Yeah, sure.
Really narrowing down our focus quite quickly, as in like week 1 and 2 to our topic.
Yep. So
we can tailor our weekly workshops to that, really, shouldn't we then?
Yes, but don't feel compelled to continue with that focus. So in other words, if your week 1 has a reference to this is the particular area that I'm looking at, and 3 weeks later it changes, that's just part of the research process. And you don't have to go back to week 1 and redo your portfolio for the purposes of making it align. It's not the point. The point of the portfolio is to get you going, not to assess you, if that makes sense, on your consistency.
Yep, that's fantastic. Thank you.
Great. I probably haven't done a great job of looking. In fact, I know I haven't at the comments as they've come up. I'm sorry about that. I'm probably a little bit out of practice with doing that, so I'll try and keep an eye on those in the future. Okay. No other questions? Thank you very much. And we'll see you next week.
Thanks, Malcolm.
Thank you.
Thank you.